Cagayan de Oro City Water District versus Honorable Emmanuel P. Pascal and Rio Verde Water Consortium Incorporated. GR number 202305, November 11, 2021. Facts of the case are as follows. The Cagayan de Oro City Water District entered into a bulk water supply agreement, BWSA, with Rio Verde Water Consortium Incorporated on December 23, 2004 to provide water to Cagayan de Oro City. Now, the agreement stipulated that Rio Verde would supply water at a rate of 10 pesos and 45 cents per cubic meter, later increased to 11 pesos and 52 cents per cubic meter through a supplemental agreement. Discrepancies arose between the BWSA and the model contract, prompting COWD to seek advice from the Office of the Government Corporate Counsel, which recommended revising the BWSA back to the terms of the model contract. Now, the Commission on Audit also investigated the agreement, finding that Rio Verde was a non-responsive bidder and that the contract violated public policy. Consequently, COA disallowed payments made to Rio Verde and recommended filing a civil case for nullity of the BWSA. Amidst these developments, Rio Verde demanded arbitration based on the BWSA's arbitration clause. COWD, however, resisted the arbitration, citing COA's ongoing investigation and the need to first resolve whether the contract was void. Now, the regional trial court ruled in favor of Rio Verde, compelling COWD to submit to arbitration. The trial court emphasized the principle of separability, which holds that an arbitration clause remains valid even if the main contract's validity is disputed. COWD sought to nullify the RTC's orders, arguing that the COA's investigation constituted a prejudicial question that should be resolved before arbitration could proceed. Now, the issue of this case is whether or not COWD, a government entity, can be compelled to arbitrate disputes with Rio Verde under a contract despite the ongoing Commission on Audit investigation into the validity of the underlying bulk water supply agreement contract. Now, the court held that yes, COWD, a government entity, can be compelled to arbitrate disputes with Rio Verde, despite the ongoing COA investigation into the validity of the subject contract. The Supreme Court dismissed COWD's petition and upheld the court's decision compelling the arbitration. The court ruled that under the doctrine of separability, the arbitration clause in the BWSA remained enforceable, regardless of the main contract's validity. The arbitration clause in a contract is considered independent of the main contract. Even if the main contract is declared void, the arbitration clause remains enforceable unless explicitly declared null and void by an arbitral tribunal. Under the competence-competence principle, the arbitral tribunal in this case has the primary jurisdiction to rule on its own competence, including the validity of the arbitration agreement and whether the dispute is subject to arbitration. In addition, the court also emphasized the policy of judicial restraint in matters involving arbitration agreements, deferring to the arbitral tribunal's competence to rule on its jurisdiction. Now, the court further explained that COA investigation did not constitute a prejudicial question that would prevent arbitration. While COA may review the propriety of public expenditures, it does not have the authority to rule on the validity of contracts, which is a judicial function.